topic today is an introduction to the Companies Act regime 2006. Now, I must emphasize that it is the Companies Act regime because there have been an enormous number of regulations that have been introduced and are still in the process of being introduced. And the whole of the Companies Act 2006 is not going to be in full effect until October 2009. There has been a very long and winding road to statutory reform since basically as long ago as 1997. And it all began, really, with the Company Law Review. Before that, there was some initial work done by the Law Commissions. That's the Law Commission for England and Wales, and also the Law Commission for Scotland. But most important of all, in my view, was the commissioning of the DTI, that's the Department of Trade and Industry, which of course has now been replaced by the Department for Business, Enterprise and Regulatory Reform, BER for short. And this DTI Company Law Review came into existence in March of 1998, and it was introduced by the then Secretary of State for Trade and Industry, Margaret Beckett, the most famous caravanner, of course, in the government. It was intended to be a fundamental and genuinely independent review of company law, albeit under the auspices of the DTI. The very idea in the draft bill was to seek to embed into statutory law the concept of enlightened shareholder value, which was much discussed by the CLR. It made it clear, thus, that directors must act in the interests of their company's shareholders by taking account of both the short-term and long-term, plus other factors like employees, the company's effect on the environment, suppliers, and customers. And this concept of enlightened shareholder value has been carried through within the Companies Act 2006 regime. First question, is the Act fully enforced now? No, it is not. A whole series of provisions have been brought into effect this month, October 2008. But as I mentioned earlier, in fact, it's going to be a whole year from now, October 2009, until the Act is fully implemented. And even recently, we've been having new regulations coming out, extensive consultations upon them. So I really would recommend you, if you want to get a grip on this particular question of the implementation, to sign up to the Department of Business and Enterprise Regulatory Reform website, and you can get regular updates as to what is coming into effect and when. It should be pointed out that the government is constantly shifting, or has constantly shifted, its ground as to the dates of implementation. Is it now the case that companies can operate with a single director, no secretary? Depends. You have to draw a distinction between private companies and public companies. And there obviously has been a significant liberalisation in relation to private companies. I described this notion of think small first. Well, perhaps more accurately, it could be described as think private company first. I would say that that is certainly the case. And in relation to private companies, I think the 2006 Act has certainly been drafted in the light of the fact that most company decision-making in private companies is via written resolution rather than by shareholders' meetings as such. The Act works on the basis that commonly in small companies, the directors and shareholders will be the very same people, i.e. because they are frequently owner-managed businesses, of course. It's also thus been fully recognised by the authors of the 2006 Act that in private companies most decision making is in fact undertaken by the directors. Yet members, strict shareholders, do have a role also in taking various company decisions, such as amending the articles and appointing the directors. From the 1st of October 2007, shareholder meetings can be distinctly streamlined. As part of this streamlining process, shareholder meetings for private companies can be on a 14-day notice period, unless the company's articles set out different arrangements. As from 1st of October 2007, in practice, the effect of the Companies Act here, 2006, is that all private company meetings are to be on 14-day notice if the articles do not state otherwise. From the 6th of April 2008, private companies no longer have to appoint a company secretary. And this is set out in section 270, subsection 1 of the Companies Act 2006. But if a private company does choose to have a secretary, a company secretary, then that secretary is to have the same responsibilities and authority as previously. And I would refer you there to Part 12 of the Companies Act 2006.